Good day, Aberdeen. Jason Ramsey from Perth, Western Australia. I'm calling in with my oral presentation for the module Arbitration Law. My last attempt went for about 14 minutes, so I have to trim or speak faster. And this is my second attempt, and hopefully I get it across the line in the right time frame. So without further ado, I'll commence. Good day, members of the Tribunal. The claimant I represent has suffered loss because of the respondent's wrongful avoidance of the contract. The claimant has commenced arbitration against respondent here in London, seeking to recover the outstanding payment and damages. And today, on behalf of the claimant, I will be addressing an argument in favour of the legitimacy of this tribunal in continuing to hear the case, and acknowledge under Article 19.1 of the Hong Kong Rules that the tribunal is empowered to decide on its jurisdiction on matters so raised. The claimant's submission on the legitimacy of this tribunal continuing to hear the case are made in four parts. The law governing the arbitration agreement is English law. Secondly, the Hong Kong rules apply and allow the tribunal to decide on its own jurisdiction. Thirdly, that the bare agreement to negotiate prior to arbitration shall not deprive the tribunal of its jurisdiction, as this provision is non-obligatory and unenforceable. Fourthly, the subject matter is arbitrable, that is, within the scope of the arbitration agreement. As a roadmap, I thought it important to reiterate three primary systems of law which bear upon an international commercial arbitration. The law governing the resolution of the substantive dispute, the law governing the agreement to arbitrate, and the law governing the arbitral tribunal and procedure. In terms of substantive law, Xanadu has a civil law system acknowledged like France, and it has been expressly agreed under Article 43. Claimant makes no submission at this juncture beyond the scope of my present remit. Law governing the agreement to arbitrate. The law governing the arbitration agreement covers interpretation and validity of the agreement to arbitrate, and also whether a particular dispute falls within the terms of an arbitration clause. The arbitration clause within the main contract is universally held to be a collateral contract in its own right. Xanadu has incorporated the model law into its own arbitration statute. In that model law, the universal principle of separability of the arbitration agreement is combined with the question of the tribunal's power to rule on its own jurisdiction. However, the Arbitration Act to which the claimant submits is the governing law does not strictly follow the unsitual model law. Nonetheless, each of these laws treats separability of jurisdiction in a virtually identical manner, and I refer to Article 30 of the Act in this respect. The most notable case, which bears strong resemblance to ours, is that of Sul America, where the substantive law of the contract was Brazil. The case turned on the determination of the proper law of the arbitration agreement, and I quote Morbic LJ, who upheld an anti-suit injunction by the application of a three-stage inquiry, insisting that, I quote, a strict order of sequence is to be observed. Absence expressed choice, which obviously has to be addressed first, there must follow an inquiry into implied choice before the issue of the closest and most real connection falls to be considered. To identify the law governing the arbitration agreement, the courts will first look at the express choice of the parties. There is no specific declaration within the dispute article of which law governed this agreement to arbitrate. So how do we answer that question? Members of the tribunal, this point is contentious on two fronts. Firstly, by excluding a choice of law option in HKIC rules, respondent may wish to argue that the substantive law and the law governing the arbitration agreement were not intended to differ. On the second front, the respondent may wish to refer to some recent cases inviting confusion on the presumption in favour of the substantive law or law of the seat, being with which the agreement to arbitrate had the closest and most real connection. I move to implied choice. In respect of the first front, respondent may submit that by omitting a choice of law in accordance with the Hong Kong rules, that they, by default, intended the substantive law to apply to the agreement to arbitrate. These rules contain an optional article, namely, and I quote, the law of this arbitration clause shall be, in brackets Hong Kong law, choice is ours. Under the guidance notes, the following qualification appears. Optional. This provision should be included particularly where the law of the substantive contract and the law of the seat are different. The assertion of the respondent may be that by inference, derived from the omission of the choice of law article, the parties did not intend for the substantive law and the seat law to differ, and the laws of Xanadu shall govern the agreement to or not to arbitrate this case. The respondent might refer to the case of Arsenovia, where Smith J. accepted that an express reference in the arbitration clause to the exclusion of certain provisions of the Indian Arbitration Act led to a natural inference that the Indian law would otherwise apply. The claimant strongly urges the tribunal not to be drawn into an overly simplistic analogy with the history of that case, as the facts are different. Any argument that the omission of the optional clause supports the application of substantive law should fail under the universally accepted principles that any exclusion of any particular law must be expressly made and not by omission. We refer to the decision of Smith J. and Arsenovia, citing the express reference in the arbitration clause to the exclusion of certain provisions of the Indian Arbitration Act, which was deemed sufficient in this respect. It now follows that there appears to be no choice made by the parties, express or implied, that we'll have to determine the alternatives, which are either the substantive law or the law of the seat shall apply. The case for the application of substantive law, on the second front, the claimant acknowledges that the respondent may wish to refer this tribunal to the Channel case to adduce that the law of the main contract will usually govern the agreement to arbitrate when no other law is specified. But claimant submits that his lordship's given position in this case, Channel, was qualified. It required the absence of exceptional circumstances. Respondents may also seek to rely on Morbic LJ and Sul America, observing that the choice of governing law provided a strong indication of the parties' intention in relation to the agreement to arbitrate. However, the principle of separability of the arbitration agreement from the substantive contract to which it relates is firmly entrenched, as we have seen recently in the authoritative case of Fiona Trust. These cases act to repudiate any automatic assumptions that the law governing the substantive contract is the law to govern the agreement to arbitrate. The choice of law may be different and deliberate, and either expressed or implied, and I refer to the case in Tamil Nadu Electricity Board, where London arbitration, in accordance with English law, was chosen in spite of the contract for the electricity supply being governed by the laws of India. Claimant refers also to a recent case of BCY versus BCZ, where the High Court in Singapore had ignored the decision in Sul America while pronouncing its judgment in First Link. This case departed from the presumption in favour of substantive law, instead taking the view that the implied choice of law should presumptively be the law of the seat. This was for reasons cited as the desire for neutrality and certainty of enforcement. However, some 2 years after this case, Chong J, reconsidering the presumptive position taken in First Link, and instead found that the substantive law was to be preferred as a matter of both precedent and principle. Chong J further supplemented his decision in BCY versus BCZ by explaining the preference for Sul America. Every case must be determined on its own merits. The circumstances of the present case are so very nearly identical and leaning towards the authority of Sul America. The tribunal is urged now to apply a three-stage inquiry per Sul America, that with the known absence of an express choice of law, to elevate the presumption of substantive law as being the same law for the arbitration clause, except where rebuttable by countervailing factors. Respondent will be likely to contest that First Link versus GT payments is persuasive in this instance. However, claimant submits the rebut by reference to the qualification given by the court in that case, and I quote, "The governing law of the main contract should only be displaced if the consequences of choosing it would negate the arbitration agreement." The present dispute is synonymous with Sul America, in that there was no indication the arbitration was intended to be enforceable by one party. The laws of Xanadu, if adopted, would pose a significant risk to the arbitration agreement, and would therefore prompt a judicial finding towards English law as the seat to govern the whole arbitration. Further, by reference to C versus D 2007, choosing London as the seat of the arbitration gave a strong indication that the parties intended English law to govern the whole arbitration. The tribunal should find the existence of a valid arbitration clause, and the tribunal will then be permitted to assume its jurisdiction in the first instance on the basis of this doctrine. Claimant prefers and submits that the rationale and decision of Sul America to be a sufficient countervailing factor for the third stage of Morbic LJ's test, as the risk is that Xanadu law, were it to govern the clause, would render the agreement to arbitrate irrelevant, which the parties could not have reasonably intended without amending the clause altogether. It follows that the tribunal will, under the universal principle of competens competens, have the authority to rule in favour of its own jurisdiction. Referring to the negotiation clause, the arbitration clause in this contract is in fact a multi-tier clause, and English courts consider the multi-tier clause in Cable and Wireless versus IBM, where it was found that a bare agreement to negotiate has no legal content and was therefore unenforceable. Respondents may wish to lead that Emirates Trading Agency versus Prime Mineral Exports, which held that such a clause could be enforceable, where there is a, and I quote, sufficiently certain and definable minimum duty. Elaborating further that where there is an unqualified reference to ADR, that duty should not be hard to find. In Ashgar and Oars versus Legal Services Commission and Anor, it noted that specifying time period obligations and the required participants was considered to be helpful in satisfying such a minimum duty. Further, respondents may submit that simple agreement to negotiate in good faith has been looked on favourably in the Australian jurisdiction with Hooper, Bailey versus Natcom. However, the tribunal should be aware of problems enforcing these simple agreements, considering the futility, I quote from that case, to enforce something which requires the cooperation and consent of a party when no cooperation and consent can be enforced. This negotiation, Article 45, in this instance, could be argued as being too equivocal or nebulous, and we refer to Tang Chun Hua as lacking in specific obligations, such time frame, unlike the aforementioned Emirates case. Respondents acknowledged Lord Mustle speaking of the Channel case, where the parties have agreed to pre-arbitration ADR processes that, and I quote, they must show good cause for departing from them. However, experts have affirmed, and I quote Philip Norton QC, that non-determinative procedures, example negotiation or mediation, would be considered unenforceable and not constituting a conditioned precedent to the tribunal assuming jurisdiction. In respect of the subject matter being arbitrable, having established that English law governs the arbitration agreement, the scope of arbitrability of the dispute is subject to English law precedents, traditionally applying a narrow construction of the phrase any dispute when referring to matters to arbitration. A narrow view potentially results in some issues being dealt with by arbitration and others by the courts. However, the decision in Halki Shipping was based predominantly on a straightforward and wide interpretation of any disputes, as specified within the arbitration clause. Further, a more recent full federal court decision in Hancock's Prospecting versus Reinhardt held that courts should give these words a wider construction so that all issues can be resolved in one forum. Accordingly, interpretation of the Article 44 reference to any dispute arising out of this contract should follow the aforementioned authorities and observe Halki adherence to Lord Justice Templeman in Elaine versus Klinger, that, and I quote, there is a dispute once money is claimed unless and until the defendants admit the sum is due and payable. It follows that any attempt to prevent arbitration on the basis of the failure to pay on the part of XUT, not being a genuine dispute, should fail. Claimant acknowledges the omission of the HKIAC boilerplate subclause, quoting any dispute regarding non-contractual obligations arising out of or relating to it, for Article 44. And acknowledged respondent may allege an impact the arbitrability of non-contractual obligations encompassing tortuous claims such as negligence, misrepresentation and pre-contractual deceit, or claims in respect of restitution or unjust enrichment. Claimant submits that for the case, for implied terms by omission of the boilerplate conditions, either by statute, custom, fact, or law is weak and should fail. The authority should again follow Arsenovia, where an express reference to an arbitration clause to the exclusion of certain provisions should equally apply to the inclusion of certain provisions. Accordingly, any dispute regarding non-contractual obligations arising out of or related to the contract is not expressly excluded by observance to the Halki ratio and the wealth of cases following this.